while I am Vice Chairman of the Parole Board of England and Wales, the views that I'm going to express in the next half hour are very much my own, and they do not represent the considered views of the board. So I'm going to address a number of different topics, all from the perspective of a judge. Firstly, from the perspective of a judge who has sat for many years in a criminal court and particularly dealing with terrorist cases, but also now as a judge sitting on a parole board deciding whether to let out those who I locked up. As you will appreciate, the functions are very different. In the UK, in criminal cases, we have the adversarial system. In parole hearings, largely as a matter of necessity, they are now largely inquisitorial. So let me start by dealing a bit with foreign fighters and returnees. The United Kingdom has already seen a large number of returnees coming back from Syria, and in the wake of recent developments, we are expecting to see many more. To help deal with this, our prosecuting teams have been expanded, as it appears to be the intention currently to prosecute returnees in the courts. The team of prosecutors that deal with terrorism cases are generally of higher quality in UK than those dealing with more routine cases. One can only hope that the increase in number does not dilute the quality. The year ending March 2017 saw the greatest number of arrests for terrorist offences in the UK since data collection began in September 2001. There were 304. That is an increase of nearly 20% on the year before, and the numbers are set to increase further. This is bound to set challenges for the justice system, but hopefully they are challenges that will be met. There has been recent controversy in the United Kingdom, stirred up in the press by comments made by Max Hill, QC, who is the United Kingdom Independent Reviewer of Terrorist Legislation, criticisms of a recent speech that he made. He argued that rather than prosecuting returnees, attempts should be made to de-radicalise them and reintegrate them into society. Whether he meant by de-radicalisation changing their beliefs, or he meant disengagement, that is withdrawing from using violent means to enforce beliefs, I do not know, and he didn't make clear. By and large, the United Kingdom press, and I suspect the public, and certainly the politicians, disagree with him, and they favour prosecution in all cases. Writing in the London Evening Standard, Hannah Stewart, an expert on terrorism and extremism, argued that what is required is that returning fighters should be appropriately risk assessed and prosecuted where possible. What she meant by appropriately risk assessed, I do not know, but I shall return to the question of risk assessment later, because I think it is a very real difficulty that we presently have with our systems, which I would be very grateful if Europe could try and do something about. So in my experience, returnees fall into two distinct groups. There are those that went to Syria intending to support the cause, became disillusioned with the reality of Islamic extremism, decided they wanted none of it, and came back either with or without the encouragement of their families. One of this group was in communication with the Times newspaper while he was in Syria. He did not allow the Times to publish what he said, and they could only publish it until he was arrested or killed. He has now been arrested in Turkey, and his correspondence with the Times has been published. He says in that correspondence that he renounced the doctrine of IS within months of arriving. He calls himself a disillusioned jihadi. He says that while he went to fight, he did not take part in any fighting and was locked up by IS for deserting his post, and after that he went into hiding. His father, writing in the same newspaper, says that his son was brainwashed by jihadists online using a mobile phone that he, the father, had given him at a young age. He is now in Turkey and is looking to return to the United Kingdom to face justice. But what will justice be for him? It is likely that he has committed the offence of preparing to commit a terrorist offence. But if his account is correct, then he's actually done nothing beyond preparation. And if that is correct, what is the point of prosecuting him? Better surely to put him to work speaking to other potential jihadists and telling them what the realities in Syria are really like, in the hope that they can be dissuaded from joining IS. But firstly, is his account correct? And more importantly, how can judges decide whether his account is correct? And secondly, if it is correct, what is the appropriate penalty? Certainly in the United Kingdom, protection of the public ranks high in the priorities for a judge when dealing with people convicted of terrorist offences. If someone has demonstrated once that they are prepared to commit terrorist offences, then they may be prepared to do so again. Even if they do feel disillusioned with jihad at the moment, will they continue to feel the same when they are exposed to the influences of extremists again? A real issue, and not an easy one to decide, as you will appreciate. And then the really burning question for the trial judge: is the returning jihadist in fact disillusioned, or having been driven out of Syria, is he simply returning to take up the struggles on the streets of London or Paris or Barcelona? To lock up someone who has done nothing and has renounced the cause and for a long period of time may seem to some to be unjust. Equally, to allow a returnee back on the streets in order to kill maybe many people would also seem to be irresponsible. So it's important that judges get it right. But what assistance do we actually have in order to do that, and where from? In criminal cases, we have the evidence in the case. That is, by definition, admissible evidence, evidence that can be shown to the defendant and put before a jury or a judge. But no doubt in many cases, the authorities, prosecuting authorities, and nor the security services, or both, will have other evidence which cannot be used in any trial, but which could shed light on which group he belongs to, a returnee because he's disillusioned, or coming back to continue the battle on the streets. The security services are unlikely to share that information with us, in my experience, and maybe for perfectly good reasons. And because they are obviously very concerned, primarily, with the security of their informants, from whom most of the information come, whose lives will be at risk if the merest hint of what they know gets out. It may be that in the case of a genuinely disillusioned jihadist, the prosecution may exercise their discretion not to prosecute, and instead to divert the returnee into one of the programs which are designed to de-radicalize or disengage. But there is a powerful argument that this should not be a matter for prosecutorial discretion. It should be a matter for a judge to decide on the basis of all the available evidence in an open and transparent way. The Sentencing Council of England and Wales is currently consulting on a proposed new guideline for sentencing in terrorist offences. Even though our Court of Appeal, in a case called Kahar, set down guidelines which increase the sentences being passed for terrorist offences to what most European countries would regard as a very high level, the guideline from the Sentencing Council has proposed further increases for less serious offences. The justification for that increase by the Sentencing Council is that the nature of terrorist attacks, as we've heard, has changed. Now lone wolf attacks are prevalent rather than the carefully prepared and planned attacks that used to occur. And as the degree of planning has always been a significant aggravating factor in sentence, it has been felt appropriate to reduce its importance, the planning, and increase the sentences for preparation of attacks, which were not carefully planned and involved very few people. The result of that is that even in the least serious of preparation cases, which will include all those who went to Syria to fight but returned without doing so, the lowest likely sentence they would receive would be one of 3 years in custody. While it is a mitigating factor that could reduce the sentence further, that there is clear evidence of a change of mindset prior to arrest, and I quote, that would be unlikely, although possible, to reduce the sentence to a non-custodial disposal. My personal view, and I emphasize this is my personal view, is that that is a misguided sentencing steer, as there are some people who have become involved in terrorist offences on the periphery or are under the influence of others who are best kept out of custody. Why? Well, we are all conscious of the risks of radicalisation in prisons. The United Kingdom is currently changing from a system of dispersing extremists over the whole prison estate to concentrating them in special units in prisons. This has come about as a result of a report which looked at the practice in other European countries, in particular Holland, but preparing those kinds of units in the United Kingdom will take time, and it will never contain all the extremists who are currently in prison in the United Kingdom, some of whom have not as yet been identified as being extremists. But whichever system is adopted, dispersal or specialist units, and I know there are differing views as to which is preferable, the risk of radicalisation remains. And if we put fringe offenders into prison, we run the risk of them coming out of prison more extreme than they went in. Surely there are some offenders who we should be attempting to de-radicalise on the outset, rather than in custody. The sentencing council proposals appear to me to be almost ruling that out. But whatever the appropriate time at the time of sentence, the very real difficulty remains for the judge, whether at the time of sentence or the time of considering parole, in identifying those who present a serious risk of committing violent offences in the future. And to do this, we need effective risk assessment tools, and we are sadly lacking in them at the moment. There are 2 principal risk assessment tools currently used in the United Kingdom, VERA 2, developed in Canada, and ERG, which is the United Kingdom version. Both seek to identify in the offender beliefs and characteristics that have been identified as being common in terrorists, and they identify interventions which are appropriate for them. Both of these tools have their critics. While the risk assessment tools are said to work in identifying areas where interventions are required, neither of the tools have been assessed on their ability to predict future risk accurately, as there are not enough terrorists who have been released on whom the assessment can be completed. We have developed in the United Kingdom an intervention called a healthy identity intervention. This can be used in custody or in the community, but again, the success rate in reducing risk cannot be evaluated. What is slightly concerning to me, and I think to those of us responsible for deciding whether it is safe to release somebody, is that both the risk and the assessment and the intervention is based on the responses of the prisoner to an interview asking a prescribed set of questions. While not in any way, and I mean this, intending or wishing to be critical of the skill of the psychologists who administer those tests, terrorists as a group tend to be more intelligent than most other criminals, leaving aside those who may have mental disorder difficulties. And those are, in general, more capable of being deceptive. So how do we get an accurate feel for the reliability of the answer that they give to the interviewer on whom the test is based? And I feel that is very difficult. So sentencing policy in the United Kingdom for terrorists gives a high priority to protection of the public, and rehabilitation comes low down the list if it is seriously considered at all. That gets the support of the public and of politicians, perfectly understandably, but I hope that we will not abandon entirely hope of rehabilitation when dealing with terrorists. As I've indicated, ironically, only the people who presently appear to consider rehabilitation as an option are the prosecuting authorities. There is a much greater use in dealing with terrorists of what are called indeterminate sentences. In an indeterminate sentence, a prisoner serves a sentence which is given a custodial part of his sentence which reflects the seriousness of the offence. When he's finished that period, he's eligible for release on licence, but he is not released until the parole board considers that he is safe to be released. The test the parole board are bound to adopt by statute is we should only release if we are satisfied that it is no longer necessary for the protection of the public that the prisoner remains confined. We have been accused by some academics, in particular those from Cambridge University, of being risk-averse. If that means we are not prepared to take risks with the safety of the public by releasing prisoners who present a danger to the public, then we have to be risk-averse because that is the test that we are bound to apply. If we do release someone who goes on to commit a serious further offence, then the parole board are held to account. If it's a terrorist offence, then it's particularly serious. In fact, very few do, but even one additional offence after they've been released is one too many for the victim. All effective systems of risk assessment rely on a multi-agency approach. They rely on information from everybody, including the counter-terrorist police and the security services. We do not get that information currently. So the parole board is making its decision without information from one of the agencies which would know. There are perfectly good reasons why we don't know, because most of it is top secret. But we are busy at the moment trying to work some system out which will comply with Article 5.4 to give a fair hearing with the use of special advocates, but will give enough information to the person who is seeking parole to know the gist of the information against him so that he can instruct his lawyers to deal with it. Believe me, it is not easy, and we haven't yet got the answer to that. But at the moment, without accurate risk assessments, it's very difficult to say you're satisfied that it's safe for the person to be released. An entirely different topic, and can I just say a bit about victims? They are important, as we just heard in the last address, clearly. The role of victims is becoming more and more important in our criminal justice system. I have no difficulty with that, but I do think we need to ensure, certainly we do in the United Kingdom, that we are not pretending to our victims that they have influence in areas where they don't have it, can't have it, and shouldn't have it. Of course, victims need to be treated with humanity and consideration by the system. They need to be kept informed of what is going on. Important decisions as to how the case is run need to be explained to them. But decisions about the conduct of the case have to be taken by independent prosecutors. We cannot have prosecutorial decisions made simply to please victims when it is the wrong decision from the legal perspective. And sometimes, I'm sure no prosecutor here would admit to it, but sometimes it may be tempting to say, well, let's let the case run because then the victims will be happy even though we think really there's no hope of success. If the decision is taken not to prosecute, the victim should be able to appeal that decision to someone independent. That is available in the United Kingdom, but victims cannot be the only ones to make that decision. In court, they should be treated with courtesy and understanding, bearing in mind they may only be alleged victims at that time. I'm obviously not talking about terrorist victims when I say that. Everyone should be treated with courtesy and understanding in court. When it comes to sentencing, it's only right that the court should know and take into account the extent of the injury, both physical and mental, that victims have suffered as a result of the crime. But victims cannot and should not dictate what the sentence should be. We already allow them, at least to instigate with the Attorney General, an appeal against the leniency of sentences in the United Kingdom. We need to make sure we do not go further. Submissions about sentence are made in our system by the prosecution and the defence, not by the victims. And victims must not be led to believe that they can decide the sentence which is imposed, which has to be left to someone who is independent and impartial, namely the judge. And criticism of the sentences by the press, which they are perfectly entitled to make, should be informed and coherent, and should not simply be a headline grabber, which simply inflames the public. And I've never had problems with the reporters in court. What I have problems with is the sub-editors which write the headlines, which seldom bears any resemblance to what actually is in the written text, and certainly bears no resemblance to what I said when I sentenced or why I did. I tried to make people understand. I hand out my sentencing remarks, typed out for them, so they get afterwards, so they can take it home and read it all and actually understand why I passed that sentence. It doesn't make any difference to the headline in. I won't name a paper because then, well, anyway, I won't name which paper, but there are a number of papers which are particularly bad about that in the United Kingdom, and it brings down the reputation of the justice system quite wrongly and inappropriately in the countries where it happens. Of course, we must have a free press. Article 10 tells us that. But it doesn't mean that they can act irresponsibly, in my view. I'm particularly concerned with the role played by victims in our parole system. Victims are, and it's worse in some other countries, victims are entitled to make a statement to the parole board. I have no problem with that. But by the time we on the parole board consider release, the prisoner has served his minimum term, which reflects the punitive and the retributive part of the sentence. So although they can make a statement emphasizing to the panel the suffering that they've gone through as a result of the crime and the ongoing impact on that, on them, on their families, and I have no problem with them doing it, my worry is that the extent of the harm is actually irrelevant to consideration of parole, which are not, we're not seeing whether the original sentence was long enough. We are asking ourselves, is it safe to release these people or not? And if victims have something to say which is relevant to future risk, then of course they must be allowed and should say it. But what they're saying about the harm the crime caused to them does not go to future risk. So it's irrelevant to our consideration. We allow them to say it. We encourage them to say it. And I think we are leading them to believe that by telling us how the crime has affected them, that in some way that's affecting whether the likelihood of parole being granted. I'm going to leave evidence because I can't say anything very relevant about it, except we don't actually have any trouble with it. But look at the slide. There's just a lot of it, but no doubt the problems will be there. But can I deal finally with evidence coming from abroad? Obtaining information from conflict zones such as Syria is impossible, as there is no functional criminal justice system there. So there's no mutual legal assistance. There will undoubtedly be problems relying on evidence from countries where there are human rights issues about how the evidence would be obtained. So the prosecuting authorities of the United Kingdom carry out a risk assessment before they even ask for help from one of those countries. Evidence obtained by torture, whatever you may think, or oppression, whatever you may think about the case of A, would never, ever be admitted in our courts, and there can be considerable doubts as to the reliability of any evidence which comes from a conflict zone. So where people are returning from Syria, the prosecution have to rely on material found on phones and computers to prove why they went to Syria and what they did when they were there. It is not an offence, in UK anyway, to travel to Syria, but it is an offence to invite support for IS, be a member of IS, or attend a training camp, or do acts preparatory to an act of terrorism. The European investigation order to which the United Kingdom opted in has worked well from the perspective of our prosecutors, I am told, who have found it effective and convenient. There are effective time limits which aid preparation of our cases. We have our own rules of admissibility in court, and it is unlikely that our courts would conclude that simply because the evidence was admissible in the executing state, that would render it admissible in our country. We're all going to keep our own rules as to admissibility. But our prosecuting authorities have been able to ask that evidence is obtained in a particular way so as to reduce any arguments as to admissibility of the evidence in our courts. There are some concerns from the defence community that insufficient attention is paid to the interests of the defendant and their human rights, and that may lead to arguments in court which must be respected and considered. And the benefits are reciprocal. The United Kingdom gathers evidence at the request of other European countries, and while there was concerns originally that requests would be made which were not proportionate, wonderful word which I don't understand, but which were not proportionate, which was perceived to be a problem with European arrest warrants, that has not applied to European investigation orders, according to my informant. Terrorism is a global threat. It affects us all wherever we are. With increased freedom of movement, it is essential that we have the ability to follow the evidence as it moves across borders. There are concerns among the legal community in the United Kingdom that the ability to do this may be lost if Brexit and when Brexit occurs. That would be pointless and dangerous from everyone's point of view, and would simply be, I suspect, the result of political point scoring on sides of the argument. And in my view, and I hope and I suspect in all of yours, the rule of law is too important a subject for political point scoring. Thank you. I'll go to my plane.